pleasure to be here today. I always love to speak to people that love the principles of liberty. As we begin here, I was worried I was getting here on time. Utah has two seasons. One is winter and one is road construction. And we went through a lot of that to get here. So I'm trusting the trip home will be probably equally exciting. I've been asked to speak on nullification today. And I'm going to leave, I'm not going to leave right now, but I'm going to leave, when I leave, I'm going to leave a 3-page resolution with probably our guys up here on the AV to get to whomever they need it in case you want copies of a generic nullification resolution. I prepared this a couple of legislatures ago for the Utah legislature. The Utah legislature said two things. One was it's too long. It's 3 pages. I wonder how long Obamacare is. If they passed that, well, Utah didn't, but it gets through somehow of the legislative session. And the other thing was they said they couldn't understand it. The reason being was because I didn't have to make up a single word in this resolution. I used the words of Thomas Jefferson, the principal author of the Declaration of Independence, and James Madison, considered the father of the Constitution. So here our legislators declined to do this. They turned it over to someone that's an enemy of nullification, and he wrote a quote-unquote nullification bill that he allowed to die in committee. The reason he's against nullification is because he's for a Constitutional Convention. If we have nullification, we do not need a Constitutional Convention. In fact, a Constitutional Convention would probably be the worst thing this nation could have happen at this time. However, I took this little 3-page document that I'm going to leave that your leadership can distribute as they choose. I took that document without any prior explanation to my wife. She loves liberty, but she's not a lawyer or has a legal mind in any way, shape, or form. And I asked her, will you read this, please, and tell me what you think? She came back in, it was just a few minutes, probably took her 15, 20 minutes to read it. And she was so thrilled, so excited, almost doing handsprings. She says, can we do this? Can we do this? This is so magnificent. This is exciting. She just went on and on about it. I says, well, did you understand it? She says, yes. I says, did you read it? She says, yes. I says, the reason you understood it is because you read it and you tried to understand it. But our legislature will not do that. There are people in the legislature that are absolutely terrified that nullification has some ties to racism and secession. And I sincerely hope that when we get done with this little presentation, this is an abbreviation of a 2-hour class I do on nullification. So we're going to get the 50,000-foot level. There's much deeper review that could be gone into, but I think you'll feel when we get done that this is a way to turn back the tide of tyranny that has been going across the nation. It is one of the most exciting things, and it's never talked about, and our legislature is terrified of it. And the reason is because they want a Constitutional Convention, because then they can change the Constitution. This last legislative session, I testified against a number of the bills that were before the state of Utah legislature, and you would be shocked at what they were trying to do. Literally and truthfully, one of them would have put at risk and it was no bones, they made no bones about it, it would put at risk every single word of the Constitution. Others ostensibly say, well, we're going to try and limit it to one thing or another, and they have these little cover-ups that they do, but it's not a solution, and it's a bad approach. So, with that, I've titled the presentation, Nullification Simplified. What we need to understand is a few fundamental truths about government that were actually defined in the Declaration of Independence. First of all, our Creator is the source of our rights. Second, that the purpose of government is to preserve those rights. Now, it's very interesting. I have discussions with state legislators all the time, and I say, what do you guys do? Oh, we spend money. We divide up the money, whatever. I mean, they have some long explanation about a tough job that they have, and they have to, boy, we do a good job with really, really a lot of things pulling on us. No, they've got it wrong. The purpose of government is to secure God-given rights. If they have to spend money to do that, okay, I'll go along with that. But we're going to see here momentarily that they've forgotten that completely. Another interesting thing is that the people have the power to alter or abolish any government, and this is a direct quote from the Declaration, whenever any form of government becomes destructive of these means, or ends, excuse me. Wow. So God gave us our rights, governments to preserve those rights, and if they start destroying it, we have an opportunity to do that. Nullification is a way to do that without revolutionary means. Okay. So the United States Constitution was created in light of these foundational principles that we find in the Declaration of Independence. The Founding Fathers understood that government is not eloquence, it's not reason, it's force. Truly, they may put a smiley face on it and a velvet glove on, but government is always force. They either take your money, your liberty, or your life. Depends on how much you resist. But that is what government does, and so it's got to be kept within proper bounds. They knew that government was to prevent force, fraud, and debauchery. In a real nutshell, that's what government is about. Now, some people include monopoly, but I don't, because monopoly is only able to be done under force. So it falls under the category of force, and oftentimes today we find monopolies are encouraged by governments, and so you've got the force of government behind whatever they're going to give a monopolistic viewpoint to. So government really is to prevent force, fraud, and debauchery. And it's really kind of a defensive in all of its activities. It protects life and property and liberty. Okay? Doesn't have any power to redistribute wealth or provide. Government does not do those things. And particularly the government that is defined under the United States Constitution. Now, we've completely forgotten those things the way we run the nation today, but that's the way the founders set it up. We could do great length explaining in detail what really is meant by this. So we've abandoned the plain English words of the United States Constitution. We've been doing that for decades. They have this concept of the living Constitution. See, the words can mean anything we want. We can define them generation to generation, or maybe even week by week. And we're going to see that that's exactly what the Supreme Court just recently did to preserve Obamacare. They decided they could redefine words to meet their end desired result. But if you accept that premise, you got to understand that we could redefine the words until we no longer had a constitution, and it just didn't exist anymore. The words have meanings. They can only mean what they meant the day they were written. There's no logical approach to anything else that the Constitution could possibly mean. So, plain English words of the Constitution, we've abandoned that. So, because of that, we've had countless unconstitutional laws that have been put into effect. These laws must be expunged. That's bottom line, and as boldly as I can put it. But how do we do that? Well, first, we the people. See, we the people are truly the cause of the problem and the solution of the problem. Because for so long, Americans have become so compliant, so complacent, so apathetic, whatever term you want to put, that we have abandoned our responsibilities in preserving our own freedom. And consequently, because of that, they can act any way they want, and we think it's okay. But we, the people, have got to regain that understanding of what is constitutionally sound. And then we've got to first elect and then insist that our representatives keep all of their actions within constitutional bounds. So it's kind of a 1-2 step. And you can't just send them to office and say, well, they're there now, and I trust them, and we could give countless examples of representatives that we have trusted far too much. They're unworthy of our trust. And that's the way it should be. Most of them I would not trust to watch my goldfish if I had one. So this is a real challenge we have today. So we've got to take some bold action. We've got to be courageous about this. And we've got to step forward with a firm understanding of where we're going. So let's understand a few critical principles, first of all, before we move forward. Now, this isn't all we need to understand by any means, but these are a few things that we're going to get thrown in our face instantly when we talk about the idea of nullification. This so-called supremacy clause of the United States Constitution, it does say that. Yeah, Article 6 of the Constitution talks about it. We'll look at that in just a second. The living Constitution, we already briefed you about that, about how it's so inspired. I mean, God really knew what he was doing. He put down things and we can interpret it any way we want. And that's what Roberts did on the Obamacare thing. In fact, he did it the last two things he did. We'll mention those specifically. And there's another one called the penumbra of the Constitution. Now, most of you attorneys out there probably never heard this word because it's not a legal term. It's not in the Constitution. There is nothing whatsoever that calls this to anything to give it power in the Constitution. It's an astronomical term, okay? It's something that they used just recently, the concept of that, to authorize same-sex marriage. Nothing whatsoever in the Constitution could be construed to allow what they just decided. But here's what penumbra means. It's out of the Webster 1828 dictionary, which is the terminology the founders used when they wrote the Constitution. It's in astronomy a partial shade or obscurity on the margin of the perfect shade in an eclipse, or between the perfect shade where the light is entirely intercepted and the full light. Okay, so I put up, you see that shadowy pretext between the main shadow and the main light? See that little kind of fringy area? Right there, I call it a fringy area on purpose. Because anybody that believes in the penumbra of the Constitution is really on the fringe. They may call us fringy because we want to obey the Constitution, but they're following something that isn't even there. It's a shadowy pretext, and they're making whole law out of it, and it's a total falsehood. We're going to address some of these things as we go through this, but let's look at something here that Joseph Goebbels, he was the chief Nazi propaganda guy for the war machine that Hitler put together. If you tell a lie big enough, this is a rough English translation, and keep repeating it, people will eventually come to believe it. So we have come to believe these falsehoods that have been taught to us, time at the living Constitution, the supremacy clause, the penumbra. Everybody throws that around like it's, oh, well, they must understand what they're talking about. I'm not an attorney, so I guess I don't. They're all false. They are not anything more than a bold-faced lie. Let's read, first of all, about this supremacy clause. Now, I'm just going to read the bold part. We're not going to take time to talk about treaties. I've got a wonderful presentation we could give after if you run out of speakers. But because treaties are truly one of the ways that we are taught we can lose our Constitution. It's an absolute falsehood, but we're not going to talk about that today. I've got to keep on track. So here's Article 6 of the Constitution. This Constitution, the laws of the United States which shall be made in pursuance thereof shall be the supreme law of the land. Now many people say, oh, see, they're the supreme. Anything that they do at the national government is the supreme and it's got to be followed. I often ask people, well, what if they legislated the color of shoelaces you wanted to wear? Well, it doesn't include that. How many children you want to have? Well, yeah, but what about it's a chain link fence or a picket fence? How about a brown roof or a blue roof? I mean, and we start all of these ludicrous little discussions and they say, well, no, not that, no, not that, no, not that. I say, well, you know what? It's a lot easier to pick the things they can legislate on than it is to pick the things they can't, because the can'ts are innumerable. And we're going to see that in a minute. And when we have these discussions, people have to come to understand, no, they don't have power to do all things if they have a mind, if they're logical at all, if they have any kind of intelligence. But it does say it's the supreme law of the land, so maybe they meant that, people will say. Well, here's what Madison said. Does it follow because of powers given to Congress that it is absolute and unlimited? The exercise of the power must be consistent with the object of the delegation. So whatever power they exercise has to be in keeping with the purpose it was given to them for. Okay, and we're going to see some examples of this as we go forward, particularly in recent Supreme Court decisions. But the fact of the matter is, we stop and think about this logically. You have to say, no, they can't legislate the color of shoelaces I wear. But even if they did mean that the United States Constitution had supremacy over all things and could dictate all things, well, right after the Constitution was ratified and brought before Congress, amendments were put forward. And the 9th and 10th Amendments clarified that it doesn't delegate supremacy in all matters. It does not. And they happened, if you look at the sequence of things, the Constitution was signed in September 1787. What became the 10 Amendments, we're not going to get into discussion of the 12 to begin with, but the ones that became our Bill of Rights were brought forth in September of 1789, and they were ratified in December of 1791. So they followed what happened in 1787. So they changed that. So if there was an intention that the United States Constitution be supreme in all things, these amendments modified that. So let's look at them. First, let's look at the preamble. The preamble, a lot of people don't know the Constitution. The Constitution has a preamble, and so does the Bill of Rights. See, at the time of adopting the Constitution, in order to prevent misconstruction or abuse of its powers, further declaratory restrictive clauses be added. So the states were saying, no, we're not going to sign this thing unless we know that there's going to be no misunderstanding where we're going with this thing. So that was the intent of the Bill of Rights. Here's the 9th Amendment. The enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So in other words, the people kept all their rights even if they weren't listed. You can use the color shoelaces you want, guys. That might be for this group it's not news, but to some groups they would say, oh no, really? You mean I can choose? Surprising. But the people have all the rights even if they didn't list them. 10th Amendment says that if we didn't give the national government power, it does not have that. If we didn't delegate it, it does not have the power. It's reserved to the states or the people. That doesn't mean the states can become tyrants. We could talk about that at length too, but that is, the national government only has what it was given. So the Supremacy Clause only grants supremacy in the area of jurisdiction that was established by the United States Constitution. It doesn't create an overarching power to usurp anything it wants. It is limited to the powers granted or delegated in the Constitution. Then James Madison followed on with a statement, it was actually stated during the Constitution Convention, a law violating a constitution established by the people themselves will be considered null and void by the judges as null and void. So the hope was that there would be judges that would read the Constitution and they'd say, oops, doesn't fit, it's unconstitutional, we're not going to go there. That was what James Madison hoped as they were in the convention. So again, Father of the Constitution, he said in Federalist 45, which was to help get the Constitution ratified, he said the powers delegated by the proposed government to the federal government are few and defined. And then he said they're exercised principally on external objects like war, peace, negotiation, foreign commerce. And by the way, he says right there, read that, with which last the power of taxation will for the most part be connected. So the truly constitutional revenue stream for the government was to primarily be coming from duties, taxes, import taxes, if you will. Now, it's interesting, again, this is a side trip that we'd love to talk about at length. We see these so-called free trade agreements where they eliminate our import duties on selected countries. That's getting rid of a constitutional tax. Does the United States lose the need for that revenue? No. So what do? They either put the revenue requirement on your back or on your grandchildren's back by taxing you or by indebting your grandchildren. So, I mean, this is totally, we're throwing out everything with everything we're doing in this nation right now. And then he goes on to say in Federalist 45 that the states are going to really be involved in the lives, liberties, and properties of the people, internal order, improvement, and prosperity of the state, if it was to be proper in government. Okay. St. George Tucker, whom I consider to be probably the preeminent constitutional scholar of the founding era, said that you can't, in any way, shape, or form, construe the Constitution beyond the letter of the Constitution itself. And he goes on to quote some of the things that are in the 10th Amendment, for example. And then James Madison, who became a member of Congress after the convention in February of 1792, he said, "This is not an indefinite government deriving its power from the general terms prefixed to the specific powers, but a limited government tied down to the specific powers which explain and define the general terms." Wished we had time to talk about every word of that, because basically he's saying any power that's there is only to fulfill the powers that we specifically said was granted to the national government. St. George Tucker was a little more succinct. He said, "It is a written contract. Government was reduced to its elements. Its object is defined, its principles ascertained, its powers limited and fixed." Oh, thank you. Okay, so it's a contract. And we're going to use that term here in just a little while, because that's the basis of nullification. Here's Thomas Jefferson, the Kentucky Resolution, 1798. We're going to see this statement a few times in this presentation. "The several states are not united in the principle of unlimited submission to their general government." Then it talks about they constitute a general government for special purposes, delegated to that government certain definite powers, reserving each state to itself the residual mass of right to their own self-government, and whenever the general government, meaning the national government, assumes undelegated powers, its acts are unauthoritative, void, and of no force. What does that mean? They're unconstitutional is what that means. He went on to say, "The government created by this compact being a constitution or a contract, was not made the exclusive or final judge of the extent of the powers delegated to itself." You're going to see here in a while, and I'm kind of overhanging this a little bit, that what we've come to in America is that this creature of the contract, the national government, is now defining its expanding powers beyond where the contract took it. And he's saying, no, you're not the final judge of the extent of your powers. It would made its discretion and not the Constitution the measure of its powers. So he's saying, if you leave that to the creature of the contract, the one that was created by it, they can run amok and do whatever they darn well please, and they are in America today. So the Founding Fathers were very, very concerned with power. They divided it and subdivided it. In fact, they went so far as to divide and subdivide the sources of power. For example, Congress has its source of power, always has the people. The people's a pretty strong motivator to get behind something. The Congress also has the power of the purse, the House. That's why Congress was only given 2 years terms, because it was given the most power. It had the power of the people and the power of the purse. And they said, if you've got that much power, we've got to limit it. So they had an inverse relationship between power and the tenure in office. Senators have 6 years. They were considered to be far less powerful. And the president got 4, and the courts got life. Oh, no, they should have got life, a lot of them. But what I'm saying is people think that it's a term for life, but it's not. It's for good behavior. And most of the Supreme Court is probably eligible for, if we had a constitutional Congress, for impeachment and then trial and removal from office because they are not behaving well according to their oath of office. But anyway, the power and sources of power were divided and subdivided. So individuals have power, states have power, federal government, and then the legislative had several different layers of divisions, including within the legislative, the House and the Senate, different sources of power until the 17th Amendment. So all of this idea was to split power up so that it was not able to become abused. And then all of those that were entities within that were to act within their specific jurisdiction. The executive cannot constitutionally create any law, nor can any office under the president's executive branch. I don't care if you are executive orders, signing statements, or if you are a department under the executive branch, like OSHA, or the BATFE, or the IRS, or you can name the alphabet soups as good as I can. They have no power whatsoever. Article 1, Section 1, Clause 1 of the United States Constitution says all legislative power herein granted is held by the House and the Senate. All inclusive, okay? So they were supposed to act within their jurisdictions. We've forgotten that too. And there's almost countless examples where we could say that the charter, the contract, the Constitution has been violated. Well, how can we fix these? There's 4 constitutional methods that we can do this. And I'm simplifying in a little way because I'm not even putting impeachment in there, because we could do this without even impeaching anybody if we really wanted to, although I'd like to see impeachment. At any rate, impeachment, by the way, is just bringing charges. The House brings charges, it's like an indictment. The Senate then has to try the charges, and then they come to they're the judge, jury, and hangman, I guess you could say. Okay, so there's 4 constitutional methods to change this. One is to repeal the offending matter in the National Congress. Okay, so how do we do that? Well, Article 1, Section 7 says the way we do that. It tells how a bill is brought before the Congress, and let's say it's a revenue bill, it originates in the House, it gets passed there, it goes over to the Senate, it's either amended or it's passed as it is. If it's amended, it comes back to a committee that reviews it, then it goes back to both houses, and it's passed exactly the same wording between both houses, then it goes to the president for signature or not. There's a veto process that's possible. There's an override process that's possible. That's a simplified version of Article 1, Section 7. But they could pass laws that said we are removing these egregious violations that violate our Constitution. That could happen. Second thing we could do is defund, not to give them any money. That shuts down things really quickly when you're dealing with government. So it couldn't be carried out. So how do you do that? Article 1, Section 7 again tells us how to do that. And then also Article 1, Section 9, Clause 7 says that you can't spend money unless the legislature appropriated. So the legislature has a process through which they do funding. And all legislative bills, all revenue bills, all money bills have to start in the House. They can be amended by the Senate, which is another problem with Obamacare, by the way, because the one that was passed started in the Senate. And nobody said, time out, unconstitutional. They don't even read it anymore. But the fact of the matter is it violated the Constitution just in its origin. And so it's another tragic thing. But the fact of the matter is that Congress controls the nation's money, not the executive. The executive cannot in any way, shape, or form, because of Article 1, Section 9, Clause 7, spend any money unless it's been legislatively approved, and the Congress could stop it. Okay? So the next thing we could do is we could seek relief through the courts. Well, Obamacare kind of dashed those hopes. They've made some decisions that really showed us where they really lack the complete backbone or knowledge or whatever it is. So back in 2012, Justice Roberts justified Obamacare by saying the power to tax is in Article 1, Section 8, so we can tax anything and everything. Do you realize how dangerous that is? That position could absolutely, completely, unequivocally control every act in our lives. They could shut it down by making it so you couldn't afford to do it. What if they put a tax of $500 per .22 shell? Well, you still got your Second Amendment. I mean, just think about these things for a second. It's appalling how he stretched on that. And again, we have Madison. Does it follow because of powers given to Congress that it is absolute and unlimited? The exercise of the power must be consistent with the object of the delegation. Roberts completely violated that. By the way, he said it's a tax, and we have the power to tax, and the law specifically says this is not a tax. So they changed the meaning of the words, too, in there. So the inconsistencies are just appalling. Then, just recently in 2015, they said words can mean anything we want them to mean in both the Constitution and the law. It's the living Constitution idea carried into a law. So the law, Obamacare, is upheld in spite of the fact that the law says exactly the opposite of the new definition the court has given it. When they said state-formed insurance markets, it now means federal-formed insurance markets. I mean, a minor distinction, right? But they've redefined the terms to meet what the elitist view says this should be. So we've had some things thrown on the rear. And Madison again said a law violating the Constitution established by the people would be considered by the judges as null and void. We found this to be completely false in the way our Supreme Court's doing it. So they've really fallen far. The executive, the courts, the legislative, we've just gone into free fall with the Constitution. in recent years. And in fact, it probably should read decades. It didn't start with Obama. For those of you that may still harbor that thought, this started 100 plus years ago. Well, the Lincoln era, I guess. Well, people ask me, when did this start? I say, before the ink was dry on the Constitution, because there was an effort to subvert it right after that. One of the earlier quotes I gave when James Madison was a congressman in 1792, there was an effort to redefine the word welfare so that it meant anything that money could be spent on. So the national government could spend money for anything they wanted to as long as there was money being spent. And he says, you guys need to understand, if you go there, you're going to destroy this nation. And that's where we are today, people. So we've fallen way down. So the fourth way to do this is by nullification by the state legislatures. It's a doctrine that was held sacred as a check and balance from the very beginning of this nation. This is stuff the Founding Fathers understood. Now, you're going to find there are people that say, oh, George Washington opposed it. George Washington felt like we need to let the nation grow some legs and start learning how to walk and then run before we start chopping legs out from underneath it. So he was reluctant to use it. Other people say James Madison opposed it because when South Carolina went to nullify a tariff, he was opposed to it. You know, we roll forward until the 1820s, late 1820s. You're going to find in a minute, and I hope I remember to tell you, why he opposed it then. And we'll see that in just a minute. But it was understood right from the very beginning. It's a right of refusal. The states which created the national government retain the constitutional right of refusal when they're faced with a usurping government. I underlined and italicized usurping, because usurping must be in the formula. Okay, so it was considered many instances in the founding era. It was taught in the constitutional law classes at the U.S. Military Academy, West Point, when it was established. So it was well-founded, and in fact, some of the leadership in the Civil War were ready to use that if they were brought to trial for treason, because it had been taught to them at their West Point classes. Anyway, what happened was to get these nullification things originally going was in 1798, the Alien and Sedition Acts were passed by the United States Congress and signed by the executive. Actually, the executive asked that Congress pass it, and then they did, and then he signed it. And it violated the issues of limited government, whose powers were few defined. It violated Bill of Rights and all those kinds of things. And so some of the people, some of the states were completely appalled by this usurpation that happened right early in the nation's history. They ignored the bounds, and so the Bill of Rights, the Constitution, were set aside when the act was signed. So some states decided that their right of refusal needed to be exercised. So Thomas Jefferson, again the principal author of the Declaration of Independence, James Madison, the father of the Constitution, collaborated in helping Virginia and Kentucky set forth an effort to nullify these acts. Okay? Kentucky adopted theirs November of 1798. The Virginia resolution was passed by the Senate in December the next month. And this is, again, an abbreviated form of a 3-page resolution that's generic. You can fill in the blanks. Put whatever act in there it is, whatever state you are, and then you date it when it passes. Again, Utah legislature did not think much of it, and they put it up. My gracious, 5 minutes, I'm told. Okay, so there are 25 key issues that I would like to talk about, and there they are. You'll get through them very quickly, I think. But no, I got them on one page. It's not secession. It will prevent secession. It will preserve the Constitution. It is to preserve the Union. It's not a rebellion, but an act of love, because it's bringing us back to our foundation. It sustains the doctrine of limited government. The Constitution doesn't say that we require unlimited submission. Okay, the government has limited defined powers, and it reiterates that. Specific jurisdiction is all we can operate in, and it says here that any of the other powers that were granted were only granted to help the national government carry out the ones that were really granted. The Supremacy Clause only allows them supremacy in the areas of their jurisdiction, and it does if we assume otherwise, the national government would grow into, completely metastasize into something it was never designed to be. All the other powers are reserved to the states or the people. Undelegated powers are illegal, null, and void, or unconstitutional. The government was created by the Constitution, the general government, that's the national government. The national government is not the exclusive or final judge of its powers, and the states reserve the rights to judge those powers if the general government begins to violate those powers not delegated to it. If left unchecked, it would result in tyranny. The states are only obligated to follow the general government in the areas of jurisdiction. The states were parties to the contract. They were the writers of the contract. All those that hold office in the federal level are creatures of the contract. What that means is they were created by the contract. They're not parties to the contract. They didn't write it. They're only holding office based on the contract itself. The creatures of the contract have no authority to assume additional powers. They can't. It's not part of the contract. In cases where delegated powers are abused, the way to remove them is by the ballot box. And where the cases of powers not delegated, the way to remove them is by state nullification. All of these things are found in the writings of Jefferson and Madison. And if the states don't do this, they're going to risk losing all of their retained powers, which is about where we are today. And if we're going to have all of our blessings of liberty, we've got to keep the national government within its delegated powers. So there's the 25 again. There's some examples we could talk about at length about how we've used nullification in history. It has been used and even recently. So we've got to reinvigorate our understanding of this. We need to do it so we don't have a constitutional convention. Because if we do have a convention, we could lose everything. This is a rifle shot to get rid of any unconstitutional actions. It does, and most of the arguments that most of the people use for a convention is that they're violating the Constitution, so we've got to change it. Well, there's logic, reason, and intelligence that says no. But the fact of the matter is they're pushing for a convention. With a nullification, you could stop it all. Again, we are not with unlimited submission. We will only have to do that which is granted to them, and it's the national government's not the exclusive judge. Okay, so here's just quickly, and we'll wrap up here soon. The national government was delegated certain powers. And what was happening with the South Carolina issue that Madison opposed was that the power to establish a tariff had been delegated to the national government. And when South Carolina says we're going to nullify that, Madison said, no, you can't. It's a delegated power. You can't, as a state, nullify something that's delegated to them. But as it says here, as Jefferson said, a change by the people would be the constitutional remedy. So the constitutional solution is vote them out. But what about undelegated powers? So they weren't delegated. Jefferson said where powers are assumed which have not been delegated, the nullification of the act is the rightful remedy. That without this right, they would be under the dominion, absolute and unlimited, of whosoever might exercise this right of judgment for them. So here we have a situation where if a power was not delegated, the states have to come back into the equation. So state nullification is the solution. Officers of the United States were creatures of the contract. They cannot constitutionally change their powers. That's executive, legislative, or judicial. Their states were the ones that are parties to the contract, and they're the makers of the contract. So when the creature of the contract, the national government, exceeds and usurps the power that was delegated to it in the national constitution, the parties of the contract, the states, have to re-engage and rein in the creatures of the contract, the national government. It makes so perfect sense. If an organization is created and it has a constitution or a contract under which it's created, and the employees that are in there begin to violate that, those that created the contract have a right to step in and correct it. And that's where the states have a right to come in and do it. We need to, again, apply this sound doctrine of nullification. And we start nullifying this. And this can be done on a state-by-state basis. And I assure you, like with the Real ID Act that you maybe saw on the slide earlier, when you get enough states with enough critical mass and they say, we're not going to go along with that, the federal government will back off. It is a check and a balance. You talk about checks and balance between the executive and the legislative. This is a check and a balance by those that created the contract. They created the creatures. The creatures have got to be kept in the sandbox that they were brought up to live in. So we've used up our time, and that was a very 50,000-foot flyover, but you need to understand this is constitutionally sound. It is not secession. It is not racist. It is not it's not intended to cause a civil war. It is there to prevent all of those things from happening. And if we have a sound understanding come again, we can do this. So I'll leave this paper that people can review in their own spare time if they'd want to, but thank you for being here. Oh, question? We'll talk afterwards if you want to. Go ahead.
I submit that nullification is our most powerful tool today and is being used in literally hundreds of examples I'm aware of around this country. I highly recommend everything you taught today. I highly recommend that the people here and their families and friends spread the word. Just here in our state, we're using it to turn off the water to the NSA building and medical marijuana. In Arizona, they're using it to put an end to a bomb here.
Absolutely, it's an unused power that we have become terrified of, and it's kind of like the treaty power thing that we've been taught, oh, you can't go there. Well, again, you're told a lie often enough, and it becomes truth. But this is a key, and that's why our legislature in Utah will not touch it, because they want a Constitution Convention. And if we did that, it would completely take all the wind out of their sails, and they would have no more leg to stand on. They don't have one to stand on anyway. But the fact of the matter is, we the people need to share this with our friends and neighbors and come to understand it. Thank you.
Unless we find a rogue government to invoke the doctrine of nullification, basically it's over. I mean, what we have to do, we can talk about this, it's not going to go anywhere unless we confront every legislator in the House with this document and confront them, let them know what they stand on. We have to, they have to be confronted, and if they don't stand up for the doctrine of nullification, then we should let the people know in their district that they're opposed to the Constitution. They're opposed to correcting unjust federal legislation. But I mean, these people have to be confronted. We have to take action. Talking about it's not going to do anything. Or spreading the word is not going to do anything. We have to confront the people who can make the decision.
And if you can come up with a better, shorter resolution, I'd say God bless you. I mean, I tend to be verbose, but I just used Jefferson and Madsen's words for this 3-pager, but if it can be abbreviated and still do the job, use it. Just use it as a thought process. But thank you very much for being here. Let's carry it forth. I agree with it. Okay.
Awesome. Wait.